All right. Well, I see we have some folks rolling into the webinar and very excited. Hi, everyone. I'm Ann Kolakowski. I'm the Director of Gift Planning Services for the University System of Maryland. And it is my pleasure to welcome you to the University System of Maryland's inaugural Wills Week. This is session number 1, and this is in recognition of National Estate Planning Awareness Week. I'm sure you all couldn't sleep last night. I know I couldn't, just with anticipation. We'll be getting underway in just a few minutes, but I want to share a little bit of housekeeping. If you're just logging on, please go ahead and put your name in the chat, where you're watching from, and maybe your campus affiliation. And most importantly, you can just put yes or no whether or not you have any kind of estate plans in place. And if you don't, you're in good company, and that's part of what we are trying to change the narrative on, because as you may know, that at least 2/3 of Americans don't have any plans in place. So we are trying to change that, and that's a big reason why we're here today. I'm happy to have some of my system colleagues here helping to monitor the chat, and I see my good friend Patty Wang just popped in. Patty is at College Park. We have John McKee from the University of Maryland in Baltimore, as well as Missy Ham-Cross, also from University of Maryland in Baltimore. Nicole is from College Park, and oh, I'm hearing the chat is disabled. Liz is sorry. Nicole is from College Park. Liz is from um, University of Maryland, Baltimore, and my colleague Linda. So, all right. So I'm hearing chat is disabled. Let's see if I can fix that. And if not, we may just have to have a chatless session, because I don't want to hold things up. And please do put your questions in the actual Q&A. Anything that Shari sees, she will answer along the way, or she'll let you know that she's going to hold it off at the end. So um, I do want to go ahead. I think we're just going to leave the chat off for now. So sorry about that, but we're going to go ahead and get started, because I know Shari has a really very full program. She wants to get to everything. And without that, I'm going to introduce Shari. Shari Fleming is a Maryland licensed attorney with a sincere desire to help individuals and families preserve and pass generational wealth while also supporting the causes they love. She's the principal of the law office of Shari Fleming. It's a law firm geared towards helping individuals and businesses protect, build, and preserve their wealth and legacy. And its practice areas include business formation and succession planning, real estate, estate planning, and estate administration, trust and probate. Shari also serves as the plan giving officer for Bowie State University here in the system, and she's responsible for the cultivation and solicitation of gifts involving estates, trusts, and other gifts that reflect deferred giving opportunities. She is a graduate of Lincoln University in Pennsylvania and the University of Maryland School of Law. Her post-law school education includes achievement of the designations of Accredited Estate Planner and Chartered Advisor in Philanthropy. And without further ado, I'm going to go ahead and turn this over to Shari. Thank you so much.
Thank you, and thank you so much for having me. Thank you for everyone who has registered and logged on today and will be listening to the recording. So the chat is disabled. I'm so sorry about that, but here's what I need everyone to do. Listen very carefully. We're trying to make the most of this hour. So use the Q&A only for questions. Some of you are putting your location in the Q&A. That's not going to work. I am looking at the Q&A, and I do want to make sure that I can substantively answer all of the questions that come through. So please only use the Q&A for your questions, and we'll have to figure out how to chat at another time, okay? So thank you. I see one question has popped in there, and we'll get to some of those in a bit. So, as Anne so eloquently mentioned, my name is Shari Fleming, and I wear two hats. I am an attorney and I am a plan giving officer, which is a philanthropy officer with Bowie State University. And so, a couple of housekeeping things also as we get into today's goals. While I am an attorney, I'm not anyone's attorney who has logged on to this webinar today. So I will not be providing legal advice. I am only giving general information that is based upon my professional opinion. And so I am going to tell everyone if you hear something that seems to resonate with you, but you're not sure how it may work, you really, really need to seek your own professional advice. That can be that of a financial planner, an accountant, an attorney, a philanthropic advisor or consultant like myself. So please make sure that you write down this information and also seek advice for yourself, because I am not advising you, only giving you information. So today's goals. We're going to go through some vocabulary related to the field of estate planning. We're going to briefly go through some estate planning tools, and I'm going to give you a brief checklist, some things that you should look out for when estate planning. I'm going to tell you this now. There are a lot of people that registered for this session, but this is a basic session. This is like estate planning 101. You really need to go to the remainder of the sessions for this week to get more information about different aspects of this presentation. So, why is estate planning needed? You may or may not feel it, but there is a huge generational wealth transfer that is taking place from the silent generation and the baby boomer generation to Generation X and the millennial generation. The reason why I say that you may not feel it is because some of the data shows that Generation X, no matter how much money they make, they still feel that they're kind of impoverished. And so when asked in a survey, what's the average salary that they would need to be comfortable, Generation X says they need about $500,000 annually to feel comfortable, not financially secure and not wealthy. And so that's why I say you may not feel it, because one of the things you'll hear me say over and over in this presentation is that I really want to get you to understand the wealth that you have. I feel that there is a lack of understanding of value. And so, because you don't see the value in what it is that you have and what it is that you possess and the legacy that you could leave, there isn't the thought that there is intricate planning needed for it. In 2022, there was a study done, and it was shown that even in the midst of the COVID pandemic, that 2 out of 3 Americans still didn't have a will. So this idea of, very apparent mortality did not make people estate plan at higher levels. And so I found that to be interesting. And again, I've already mentioned this, 1 in 3 Americans do not have a will or a living trust because they claim that they do not have enough assets. So this conversation is not about enough. Everybody needs to go to therapy to figure out what is enough for them. But if you have something, if you are working, everyone on here is either an alum, an employee, you are working, you have something that you can pass. What you feel about it, we need to change that culture around it, but you need to make sure that you see the value to pass it correctly. So here is our agenda. I'm going to first go over a summary of some estate planning tools, and then we're going to go into them in just a little bit more detail. There is another session this week that goes into even greater detail. And so the way that I break this up is really for educational purposes and understanding. So we're going to do a summary of the tools, and then they're really broken up into 2 components. That's planning for disability, that's planning for a time that you may be incapacitated and unable to really make your own decisions. Then there is planning for wealth transfer. I don't say planning for death just because it doesn't sound well, but planning for a wealth transfer. Also, I don't say planning for death because a wealth transfer can take place in life. And so, and we'll talk about some of that in trust. And so it's really planning to transfer your wealth in the most efficient way possible. So, what are the estate planning tools? So, we have an advanced medical directive and durable power of attorney. Those are the first two line items. Those are the tools to plan for disability. An advanced medical directive is a document that is used in the medical world to one identify an agent to make decisions for you in the event that you're incapacitated. And the second part is you're able to give that agent and your doctors some information about the type of treatment that you would want. So there are two components to advanced medical directive. Again, the first is the healthcare proxy. That's where you're naming an agent. You may also hear this, if for a healthcare proxy, you may also hear the term uh, medical power of attorney, where you're really just giving someone else the authority to make decisions for you in the event that you are incapacitated. A living will is really a trick play on words. I have not done the study to determine why we decided to call it a living will because it's very confusing. A living will is not a will in the way of a last will and testament. A living will is the second component of your advanced medical directive, where while you are living, you are giving instruction to your agent, your healthcare proxy, as well as your medical professionals about the treatment that you would want. And so we'll go into that in more detail later. I just find that we need to hear things multiple times. So I want to make sure I go through a summary. Your durable power of attorney, again, is a document that is in place in contemplation of a possible time of incapacity. This is for financial reasons. So, advanced medical directives is medical, durable power of attorney is financial. The term durable is very important because that term means that the agent that you put in place will remain in place even if you encounter a temporary or permanent incapacity. And so we'll go into that a little bit more detail, but the key term in durable power of attorney is durable. The next two or the next three on the list of estate planning tools, I consider them to be estate planning tools because estate planning is comprehensive. It's not just about the legal documents, the last will and testament, and the trust document, but it's also about all of the other ways in which you can pass your assets from your estate to your beneficiaries. And so beneficiary designations are extremely important estate planning tools, particularly for life insurance and for retirement. These are contracts that you have with providers, with financial institutions, where you are paying into a retirement program or you are paying into a life insurance policy for a particular reason, and you can name beneficiaries. It's very important that you consider who your beneficiaries are because you have to make sure that the recipient of those assets flow in comprehensively with your overall estate planning goals. TOD means transferable on death. POD means payable upon death. They are, I use them interchangeably, but transferable means something that transfers, like a title to a home or stock transfers, whereas payable means that things that can be paid out, bank account assets can be paid out or transferred. So that's the nuance between TOD and POD. But Maryland has a statute in particular that allows most financial institutions to get you to name a designee, a beneficiary of your bank account, a beneficiary of some of your stock accounts, not all stocks, but some. It depends on what they are. And so, again, this is another way that you can transfer wealth in a very easy fashion that is outside of a will or a trust. The next estate planning tool is a life estate deed. Now, this is a gift in Maryland common law. Let me also say, when I am doing this presentation, I'm a Maryland licensed attorney. I'm not licensed in any other jurisdiction. I do know law in other jurisdictions just because I've studied it for personal reasons, for family. But I am a Maryland licensed attorney. So all of the examples I am giving they are germane to Maryland and not any other jurisdiction. So if you are a resident of Washington, D.C., Delaware, someplace else, you need to make sure that you contact legal counsel in that state, because this information in this webinar, it's really only pertaining to Maryland. So life estate deeds, they are specific gift in common law, and they function really like a transferable upon death deed. So DC does have a transferable upon death deeds. And so essentially with a life estate deed, someone who owns real estate, who knows who they want the real estate to transfer to, and that person meets certain criteria. Well, let me say this, that person doesn't have to meet any criteria. It could be a minor, it could be an adult. There are some reasons why you don't want to do this with certain adults and with minors, and that is specific. You would have to get specific legal advice about that. But a life estate deed essentially allows a person who owns real estate to draft a deed keeping possession and ownership, or just possession, with whichever you want, one or both, of the real estate. And upon their death, the title automatically transfers to what we will call a remainder person. So a perfect example, and my husband and I, we own our home, and we can say, well, we want to maintain a life estate for both of our lives. So depending on who survives the other, statistics show I might survive him, who the last person standing remains the life tenant. And upon our death, we can name our 3 children, or maybe even one of our children, as the remainder person. And so the benefit is that by deed, ownership directly passes to the children or the child or whomever. It doesn't have to be our children. We would choose our children, but would pass directly to the remainder person without going through a Maryland probate. This is one of the best kept secrets in Maryland law that most people don't know about. So I do encourage you to do your research, and again, seek legal counsel, because it doesn't pertain to everyone. There is some concerns as it pertains to the property having a mortgage. And like I said, we really need to look at who the remainder person is and whether or not they are suitable to be placed in this role. But it is a great tool, similar to that of a POD, similar to that of beneficiary designations. Our last 2 tools, and see, they're last. Everyone comes to these presentations focused on these 2 things, and they are last on my list. And that is a last will and testament, which transfers, which is you giving your last testament to the world about what you want to happen with the things that you own, and who you want them to go to, and who you want to be in charge of your estate. Trusts are nothing more than a contract. It's a written agreement. With a trust, I like to give an example of a trust bucket, where the trust bucket is the trust agreement. And everything that you put into the bucket, meaning everything that you rename or retitle into the bucket, becomes a trust asset. And so you see the terms revocable and irrevocable on the agenda. Revocable means that you, the current owner of the asset, you hold the trust bucket, meaning you are the trustee, and you can revoke. You can put items in the trust bucket. You can take items out the trust bucket. You can redeed your house into the name of the trust. You can change the deed and put the deed in your name or someone else's name. You reserve the right to revoke the trust. Irrevocable means just that. Once you put items in the trust bucket, they are bound by the terms and conditions of the trust agreement. And it becomes really difficult to revoke it. And there's this process called decanting, where it's similar to when you hear of decanting of wine, where you have to break down the structure in order to figure out what to do with the contents. That is a very tedious legal process that you don't want to go into. But with an irrevocable trust, essentially, you're not holding the trust bucket, meaning you're not the trustee. You are naming a third party, another person, to be the trustee, to hold the trust bucket. Therefore, when you put an asset into the trust bucket, it's in there. And it becomes a very difficult process to get it out. And so you want to make sure that you're comfortable with losing some sort of control over the asset that will be held by this third person. So a couple of questions I'll go through really quickly because I know you need answers in real time. So how do you do TOD? Contact your financial institution and ask them for a document. For beneficiaries, are these automatically defaulted to the spouse? No, the beneficiary is who you name. And if you have not named a beneficiary, it will default to your estate, which totally defeats the purpose of a beneficiary designation. Are beneficiaries on an investment account responsible for any kind of taxes, or does the balance convey tax-free? It depends on the type of investment account. You need to talk to a financial advisor or your investment broker, because the answer is it depends. Who can the remainder person be? The remainder person, as I said, can be any human being that you name. It can be children. Children can own assets. There's complication of children owning assets, and we'll talk about that in the last will and testament. Does the life estate only apply to land and property, or does it apply to vehicles? So let me say this. When researching life estate deeds back to its origin, when I'm talking about property, when I say the term property, I'm not just talking about real property. So I intentionally use the term real estate when I'm talking about the ground, the improvement, the house, the building, airspace rights, mineral rights. All of those things are real estate. When I'm saying property, I mean anything that you own. That can be real estate, that can be intellectual property, things created, things made by your creation, manuscripts, books, sound recordings. Those are property. Vehicles, that's personal property. The clothes that you own, memorabilia, all of those things are called personal property. So when I'm referring to property, I'm referring to everything. Real estate is real estate. Personal property are things you can touch with your five senses. And then you have intellectual property. So when you look at the history of life estate deeds, particularly in Maryland, it was not in real estate, it was in people. Okay. Enslaved people were the first time that you see the transfer of human beings who are enslaved to other owners for their lives. And so to answer your question, life estate deeds now in current day is predominantly related to real estate, but historically and contextually in this state, it started with human beings. Okay, what is the look back for trust? You have a very specific question, Debbie, and I'm not sure if you're referring to Medicaid planning, but I'll talk about that a little later. Would you put savings and checkings accounts in a trust bucket? It depends on whether or not you have bills that need to be paid. So if you have bills that need to be paid, they probably should be paid out of a trust, and therefore you will need a checking or savings account. How do you get a life estate deed? You can draft one yourself, take the chance, record it with land records, or you can go to an attorney. I do them all the time as a part of estate planning for my clients. How often should I update a will? I'll talk about that later. Shaquan, you have a very specific question. I don't know that I can answer that. Yes, thank you, Catherine. So if you own a vehicle and you do not have a lien on that vehicle, and that vehicle is not a lease, meaning that you own that vehicle outright, you can go to the Maryland, the MVA, Vehicle Administration, I'm not sure, MVA, and you can do a beneficiary designation to transfer that vehicle, very similar to, again, it's a beneficiary designation. So it can pass, not subject to your will. Okay. I think I answered all of those questions really quickly. So, advanced medical directive and long term care planning, I already went into this a little bit. It does two things: you appoint a healthcare agent, and you also provide guidance to that agent about the decisions you would have them to make. The healthcare agent, the advanced medical directive, gives the healthcare agent access to your medical information. They are covered under HIPAA. They can provide consent, withhold consent, select your doctors, decide the treatment that you want. This is a very powerful position. So, whoever you name as agent, just as a key point, it should be someone that you're comfortable discussing your current healthcare with. If you're not comfortable discussing your healthcare with your children, you probably should not name your child as a healthcare agent. You probably should pick a spouse, a friend, or someone else with whom you currently share your health information with. Your treatment preferences, there are three types of conditions that are contemplated, and there are different types of treatment per condition. The first condition is when there's a terminal condition that's imminent, life sustaining procedures will not sustain your life. The question is, how do you want to be treated in that situation? The second is there is a permanent unconsciousness, similar to a vegetative state. How do you want to be treated in that type of condition? It may not be the same as if if you had a terminal condition. End stage conditions are advanced and progressive and incurable. So think about an end stage cancer, think about a dementia, somewhere where there is increased dependency over time and increased incapacitation over time. Your treatment with an end stage condition may be different from the other two, because there may be a time when you have complete capacity and you're able to make decisions, and then the next day you're not. But the following day you may be able to. And so again, your treatment, the way that you would want your agent to make decisions for you in these different conditions may differ. And so when I do estate plans with people, I find that my clients spend so much time thinking about their assets and money and not how they want to age. How do you want to age? And I have had the pleasure and the benefit of, and I say pleasure because it was that, watching my grandparents age and watch my father-in-law was on hospice care for a time. And so the question comes up, what type of treatment do you really want medically? What do you want around? What type of music do you want played? I've been very specific with my children. I've been getting my nails done since I was 14 years old. My nails will always be done. I got my first job just to maintain this very expensive habit of getting my nails done. So if I ever find myself during a state of incapacity, my children have one job. They are to make sure that my nails are done. Unless the doctors say it is not medically sound to do, they are to make sure that my nails are done, and they are to make sure that my hair is done, because my appearance matters to me. It always has. And so those are things that I want you to think about and consider, because I find that when people get to these stages, part of the hardship in it is that they haven't had these conversations with their loved ones. And so there is a presentation later on this week by Malika Moore, who is a social worker who is phenomenal. I brought her into a lot of my clients' cases to help them navigate what it is to work with someone who is ill and who may be transitioning. And so really take time to think about this aspect of it, because this is the stage where a lot of my clients get stuck in their planning. While we're talking about advanced medical directives, I also want to spend some time talking about long-term care planning. How are you going to age? Do you want to age in place? Do you anticipate needing nursing facility level of care? Do you anticipate needing senior living? What is it? How are you going to age? And more importantly, who's going to help you? Because we all have increased dependency. Who's going to help you, and who is going to pay for it, and how? Everyone, as they are gearing towards retirement, needs to think about this because our family dynamics have changed. We're no longer all living on the same street. A community is not the same that it used to be. You cannot rely on your children. Unfortunately, I see way too many clients who relied on their children without discussion, and their children are off living in the wind, having a great time in life. So you need to have questions about who will provide you support, who's going to pay for the support, and where's the money going to come from. Are you paying for a plan? Are you looking for retirement? Are you going to have government funded care, Medicaid, Medicare, the VA? What are your sources that you can rely on? Because long-term planning is a legal field onto itself. So you have retirement planning, you have estate planning, and you have a long-term care planning. It's a legal field unto itself. So when there was a question about the 5-year look back, I can't answer that question in a vacuum without more detail because there's so much. Just one thing for you to know. If you say to yourself, you know what, as I age, I may need medical care. I may need increased care. If you need Medicaid, Medicaid will give you the care that you need if you need nursing facility level of care, and they will also place a lien on your assets once that care is finished. And so you want to make sure that you are doing your planning enough time in advance. Why? Because Medicaid doesn't look at your current asset. Well, let me take that back. That not only do they look at your current assets and income, but they look at your assets and income from 5 years backwards. So if you think, oh, I'm going to sell a house and I'm going to get rid of this asset, you need to do that well in advance. And there is some Medicaid planning that needs to take place. For all of my veterans who are paying attention to this webinar, that time frame is not 5 years, it's 3 years. And so if there are some VA benefits that you may need, you need to plan in advance. And in my experience, no one prepares for illness because we think that it's not going to happen. And no one's prepared when it comes. And so it becomes very expensive to handle. So let me see. What are the questions that I missed? There is the long things I'm not reading. I tell you that right now. That is a legal question, Shannon. I can't get to that. Let's see, what are the disadvantages of a life estate deed? It depends on who you are, the property, the location, whether or not there's a mortgage. That requires legal advice. Are you able to update your advanced medical directive? Yes, all the time. Actually, one of the resources at the end of this, you can go to the Maryland Attorney General's website and pull off an advanced directive yourself. As long as it's executed the right way and the instructions are there, you can complete an advanced medical directive as many times as you want. Does a deed supersede a will in the state of Maryland? Yes, because whoever the owner is on the deed is the owner. You can put in your will that you want to give 50 properties to someone. If you don't own those properties, you can't will them. So yes, a deed supersedes a will. Is there a separate insurance for long-term care? Yes, that's not my expertise, so you need to speak with a financial planner. Can you share how much this planning will cost? It honestly depends on what planning you need. So I will share that up front with you. Not all attorneys do it the same way. I'll share the way that I do it. I find most people don't know what they want and don't know what they need. And so there needs to be an assessment of their estate. So my estate planning is in two stages. First, I do a consultation where you give me all the information. I do an assessment. I give you recommendations. The second stage is actually planning and walking out, doing a legal documentation for those recommendations. Some attorneys do it that way. Not all attorneys do it that way. Again, this is my professional way of doing it. You may find someone else that does it differently. What if the property is titled as joint tenant? So that means that both people own it, usually with right of survivorship, and so it goes to the other person. I cannot provide links. Attorney General's website. You can go to Maryland Attorney General's website. Can you change property ownership from joint to tenants in common? Yes, you can, but once multiple people own property, you need all owners to make the change. Okay. So powers of attorney. Powers of attorney are essentially you giving authority to someone else to act as your agent for financial matters. For purposes of clarity, this is not specific to estate planning or not just localized to estate planning. A power of attorney can be used for anything. If you ever purchased a house, you probably signed a power of attorney at closing just to give authority to the mortgage company or the title agency to make changes to any of the documents if there was some kind of minor error. Okay. If my sister-in-law lives in Florida, if I wanted to buy a vacation home, me and my husband have no problem giving her power of attorney to go ahead, pick out the home, do whatever you need to on our behalf. We'll make sure the finances are covered. So it's not specific to estate planning. However, a power of attorney becomes an estate planning tool when it is durable, meaning that you are given authority to someone else in advance to make decisions for you in the event of incapacity. Okay, so you are the principal. The person you're giving power to is the agent, and they can make decisions for you. And so there are different types of powers of attorney, limited versus general. So limited will be the example of giving a specific authority to the title agent during closing for settlement. It will be the example of me giving a limited power of attorney to my sister-in-law for purchasing a home. General power of attorney is typically what we see in the way of estate planning, because you don't know what's going to happen when you're with your finances when you're incapacitated. So general power of attorney is typically what we see in the way of estate planning. Springing versus immediately effective. Immediately effective is self-explanatory. Springing means that the power of attorney springs into effect upon certification of your incapacity, usually by two of your treating physicians. A note about springing power of attorneys, because everyone usually say, oh, that's great, that's wonderful, that's what I want. I don't want authority to kick in effect until I am incapacitated. And then I have to have the conversation about why. Why don't you want this to become effective until you're incapacitated? And again, I don't have a dog in a fight. I don't know if that's a good example or a good saying, but I just want to know why, because my general thought is if the basis of you deciding to have a springing power of attorney is rooted in trust or distrust, that person shouldn't be your agent at all. Take them off the list. Take them off the list. But if the basis is in some other reason, then we can talk about that. Because as a practical measure, sometimes it can be very difficult for a person to get letters certifying your incapacitation in order for the power of attorney to become effective. Not saying that it can't happen. It absolutely can, but it can be difficult and cause delay. And so I am more interested in the execution of your estate plan. So I want to know why springing. I have a lot of people that do springing, but we have to talk through why springing. Okay, so think about that when you're selecting your agents. Durable versus only effective during the principal's capacity. Again, in common law, if you were incapacitated, that means that you were not able to give someone else authority to make decisions for you. But by law, by statute, Maryland presumes that the power of attorney is durable unless you've stated otherwise in the document, meaning you want to make sure if you're pulling these documents off the internet, I cannot tell you how many adult children come to me with a power of attorney for their incapacitated parent, wanting me to do a deed change or some other legal action, and they don't have a durable power of attorney. So your power of attorney doesn't have to say it, but it could and probably should say that this power of attorney is durable. What you want to make sure that it doesn't say is that it's not durable. You want to make sure that you're reading carefully if you're pulling these documents off of the internet. Again, if you go to the Office of the Attorney General's website, they give you the link to the statute where you're able to pull the language off for a power of attorney. So before we go, let me see if we have any questions. In the absence of a power of attorney, does the spouse or next of kin have any rights or abilities? Not necessarily. Not necessarily. It depends on whether or not it's jointly owned. I want you to realize that your relation to a person does not give them access to what you own. For a time, I did a lot of presentations for males because I had a lot of men groups for some reason wanted me to do presentations because they had separate accounts and they didn't want their wives on accounts. And that's whatever you do, float, let it float. Be happy, be happy. However, if you are the only person on that account in your marriage, your spouse does not have automatic access to your financial information. And that is what it is. So no, the nature of that does not make that possible. Is a POA designation legal just by having notarized copies? At the end, I'll talk about what makes a power of attorney effective. A power of attorney in the state of Maryland has to be witnessed in the has to be signed in the presence of two witnesses and notarized. If it's not, it won't be accepted in Maryland. My husband has no one on his account. What happens with the monies in it? If he is disabled or transitioned, the funds will stay there. For a power of attorney, how does the first guardian legally refuse to be guardian? Catherine, I don't understand your question. We'll come back to that. Maybe you can ask that live later on in the presentation. Any suggestions on when you are a POA for a parent or for a parent experience dementia? She doesn't acknowledge it because of the dementia. So if you are a power of attorney and you have a properly designated document, I don't understand what the question is, who's acknowledging it. What I will say, if you have a properly executed power of attorney, by law, financial institutions are required to accept it. If they're not accepting it, my question is whether or not it's properly executed. We'll go through trust later. If a person health insurance, okay. If your questions are really long, I'm not going to go through them right now. We'll go through them later. So, planning for wealth transfer. Intestacy. Intestacy is the legal status that a person is in when they pass away without a will. When you expire without a last will and testament, you have the status of intestate. What that means is that the law of the jurisdiction of your primary domicile will govern what happens with your assets and or your property, and it will dictate to whom they actually go to. There is a formula in law that states who it goes to, and you will be surprised that is not what you think. So you want to make sure that you become familiar with that, because a lot of people don't realize things don't automatically always go to a spouse. Things don't automatically go to your children, particularly if your children are adults. If you have stepchildren, things don't go to them at all. If you do want items to go to your stepchildren. A note about intestacy. I think I saw a question in here about property in multiple jurisdictions. If you die without a will, every location, every state where you have real estate, there will need to be a probate. It's called, you will have a primary probate in a state where your primary residence is, and you'll have an ancillary probate in every state where you have real estate. If you pass away with a will, you still will have primary probate and ancillary probate. Okay. And so someone asks, what are the benefits of a trust? That's one benefit of a trust. If you have real estate in multiple jurisdictions. So planning for wealth transfer. Some people estate plan because of estate and inheritance tax. Most people will not meet the federal and state estate tax limits. So this year, if your assets are worth more than $13.6 million, double to $27 a million, excuse me, dollars if you're a married couple. Anything, if your estate is below that amount, your assets transfer free of estate tax. If your assets are more than that 13.6 million, you pay a estate tax. Most of my clients are middle America. They never touch that number. The reason why you want to be aware of estate tax, however, is because that number in a close future without legislation will drop down to the Maryland estate tax number, which is 5 million. So if you have assets that are more, your assets total to be more than $5 million, 10 million for a married couple, then you will pay Maryland estate tax. And so if without legislation, the federal exemption limit will drop down closer to the Maryland limit. I do find that a lot of Marylanders are knocking on that $5 million door. Think about your retirement, your insurance, if you own multiple parcels of real estate, bank accounts, stock accounts. When you put all of those things together for a single person, it's very easy to get to that 5 million. I find that most married people may not get to the 10 million, but it is a point of planning. Another point of planning is inheritance tax. And I think the most important point in Maryland, we have a 10% inheritance tax, which goes to everyone, which attaches to property transferred to people who are not lineal descendants, meaning parents, children, spouses of those children. So if you have nieces, nephews, friends that you want to give things to, there will be an inheritance tax attached to the value of the property that you're transferring to them. Just a note about marriage, civil unions, and registered domestic partnerships. I practice law, and I said I would never go into family law. I did not want to go into family law, and I did not go into family law, but I went into estates and trusts. And I find that over the past 3 years, I have an increased client population of people who are in civil unions and domestic partnerships because of the changes in the law, particularly when you own real estate with one another. And so this is just a note that there's a requirement to be in a domestic partnership over 18 years of age, not related to one another by 4 degrees of consanguinity, not in a relationship with no one else, and you have a mutual interdependence on one another, which has certain documents. I find that most people who are in long-term non-marital relationships find themselves in a domestic partnership. And so this is a new place of estate planning that I've embarked upon over the past couple of years. And so enough to put a note in here for you to kind of check the box as to whether or not you're in one of these to determine what you need to know in planning. Okay, and the reason why I'm not going too much into it is because marriage, civil unions, and registered domestic partnerships, from a perspective of estates and trust law, are treated very similar with little nuances. So I'm not going to go into the weeds on that. Just a note for you to know what to look out for when planning. And so not all property passes through the will, because everyone wants to know about last will and testaments. So remember, I talked about beneficiary designations, POD designations, life estate deeds. Those are all items that can pass to beneficiaries, not through your will. Your will only covers, let me explain it this way. Things that pass by operation of law or operation of contract will supersede what's in your will. So payable upon death is operation of law. There's a statute that allows you to name a beneficiary. Life estate deeds, that's operation of law. So someone asks, will a deed supersede a will? Yes, because the operation of law will supersede your will. Retirement plans, insurance plans, those are contracts. Those are operation of contracts. So wherever you name a beneficiary, those will supersede what you put in your will. And that's why I mention it up front, because it becomes very important that the beneficiaries you name are in line with your total estate plan. Your will cover everything else. So property that is jointly owned, joint tenants with right of survivorship, meaning that 2 or more people own it it, and as one person passes away, the whole of the property passes to the other owner or the other owners. That's operation of law, not covered by your will. Tenants in common is different, where there are joint owners. However, they only own a portion. So you own 50, I own 50. Your 50% owned in tenants in common will pass through to your will. And so those are the nuances that you really need to understand when planning. And so the one thing, in a personal example, my mother just passed away in January in a car accident. She was 60 years old. No one was preparing for her to leave this earth. I know, I'm always planning. I'm always planning. And so my mother was a breast cancer survivor. So when she went through her treatment, probably around 2012, I was just like, where's the life insurance? What's going on? Let's get it going. So my mother has always had adequate coverage, and she had named me 50%, and then my two daughters at the time, and then I had a third daughter together. We're the beneficiaries of her life insurance policy. And for at least 2 years, one life insurance policy, let me say, for at least 2 years, I would say to her, ma'am, take these children off because it's my preference, because I'm the mother. I take care of these kids. I know you want to leave something for them, but administratively, it's a lot of work when you leave stuff for a child. It's a lot of work for a parent or guardian to actually get those assets to them. By law, yes, it goes to them, but it's a lot of work to get it done. But she never did it. And so that's something that passed directly to me, free of probate, passed directly to my children, free of probate, a lot of paperwork, but it passed to us by operation, I said a law, sorry, operation of contract. She was a teacher within the school system in South Carolina for 2 years. And so I can imagine that she just got access to her retirement plan. She did not have a lot of retirement funds in there. And so she just didn't set it up the way that she should have. She did not name a beneficiary. And probably she was thinking, I don't have much money in there, so it doesn't matter. What she did not realize is that that particular school system pays out a year's salary, even if you don't have a lot of retirement benefits. So it was enough to seek. I had to open up a probate in South Carolina just to have access to my mother's retirement plan benefits, because she did not name a beneficiary. Me, my children, family members, no one. And so because a beneficiary wasn't named, I had to open up a probate. Was it a tedious process? No, maybe because I'm used to doing it. I didn't find it to be a lot of work, but it was a process nonetheless that didn't have to exist if a beneficiary could be named. So I'm saying all of this to you all because even the estate planner has parents and family members who don't do what I tell them to do. But the people who remain here are still left doing the work. And so just be mindful of the beneficiaries to ensure that your plan is functioning comprehensively. You can't take it with you. So plan for it all. And if you're 18 years of age or older and you're legally competent, make a will. Your will covers your funeral provisions. Just a note, as a practical measure, you pass away, the funeral home is the only party at that time that is able to access a death certificate, which is the key to everything financial and estate planning. And so there needs to be a way made in your estate plan to prepay for your funeral, because your will doesn't pay for your funeral. Your will only allows whoever pays to be reimbursed by assets in the estate. So when you're thinking about life insurance and you're thinking about cash on hand, you need to think and say, okay, well, the person I put in charge, the power of the personal representative, how do they actually access this information, this cash, to arrange for my services? Those are the things that go into estate planning. Designate guardians for your minor children is another important part of estate planning. And anything that you hold dear that may not have financial significance needs to be in your will, because families fight over the heirloom more than they fight over the cash. My family, it happened with my mother passing. Me and my aunt had to have a real conversation about the cast iron skillet. I took the cast iron skillet. It was a real thing. Okay. So I want you to realize and think about the things that actually matter to people. All right, safekeeping. You can file your will once executed properly with the Register of Wills for your county, or you can keep it someplace where it will be maintained. And so I already mentioned a little bit what happens upon death in the funeral process. At some point after that, your personal representative or whoever's in charge of your estate will have copy of your death certificate and will then admit your will to probate for the in the county of your jurisdiction. And it is at that time that the actual transfer happens. At a minimum, it's a 9-month process. A lot of people make probate seem like a really hard and nasty thing. I find that it's not. I find that most people need that time because they're not prepared to transfer these assets anyway. I don't. I find that Maryland probate is a fairly simple process and cost effective process as opposed to other states. But that's my legal and professional opinion. Trust. You have trust primarily to avoid probate and keep your assets private. But remember this, it is only the assets that you're retitling to the trust bucket. If you don't retitle your house, if you don't retitle your car, if you don't rename your bank account, it is not a trust asset. It is within your regular estate. Another note is that even if you have a will and you have no assets, it still has to be probated. So this whole idea of avoiding probate is not real conceptually. What you want to do is minimize the assets that have to get court approval to pass. But for trust, these are the benefits of having them: privacy, leaving specific instructions with the trustee, protecting assets from your irresponsible loved ones or maybe minors and their creditors. If you have a child with special needs, you may not want to put assets in their name because they're entitled to government entitlements. And so having a trust for them may be a good thing. If you're aging and we're doing real long-term care planning, removing assets from your ownership into an irrevocable trust. This is why I gave the explanation earlier. You want to remove it to an irrevocable trust. So you're removing it out of your ownership, out of your control. I find, and notice taxes is the last one because taxes is not big on a lot of people's agenda, but I find in practice that when we really have discussion and counseling about irrevocable trust, that most people are not emotionally prepared to depart with having control and ownership over an asset in order to put it in an irrevocable trust. Because remember, someone else has to hold the trust bucket. When you retitle that asset, you put your instructions in that trust agreement and you let it go. You let it go, and it is now controlled by that trustee. Could be for your benefit or for the benefit of others. I find that as many people come to me and wanting a trust, they're not prepared to really let go of the asset. So if you are considering an irrevocable trust, that's your first consideration. How comfortable are you with letting someone else have complete control over the thing that you have developed? Some people are completely comfortable with it. Most people are not. Types of trust, I've already said this. These are the buckets I put them in just to make them easier. There are like 27 named trusts, okay? And they all do one of these three things. It's revocable, where it's avoiding probate and private. It's managed by yourself, and upon your death and incapacity, you're naming a successor trustee. It does not minimize your taxes because you still have control over it. Irrevocable, it avoids probate, serves as asset protection and minimizes your taxes. Why? Because you don't own it and you no longer have control over it. Testamentary trust is a trust that's created through your will. This is not private because your will is probated, and the trust and everyone will know that you created a trust from the assets. However, there are still some reasons why a testamentary trust will work in certain situations. Again, everything does require for an assessment of your assets and your goals to be done. And so here's a quick checklist that I want to give you. Identify who you have. Who are your friends? Who are your family? Who can serve as agent? Who will be beneficiary? Do you have any charities that you want to support? And again, a personal note, I'm my mother's only child. I had a life insurance policy where I was the insured, she was the beneficiary. Just in case something happened, I want to make sure that she's taken care of. Well, my mother predeceased me before we wanted her to, but I still have this policy. Well, this is a great time. How can I honor her? Instead of my mother being a beneficiary, I can now use the insurance policy to create an endowment or a scholarship in her name with the charitable institution of my choice, most likely my college, my alma mater. And so it's something that I'm considering, but I have to go through, who do I have? Does it make sense for me to do that right now? Do my children need more money? I don't know. So it's something that I'm assessing. Itemize, what do you have? Literally, whatever you use to keep your finances, you can use a marble notebook, or you can use Quicken, or you can have a financial advisor. You need to itemize what you have, and that's not just your money in your accounts. That's also the memorabilia, the family heirlooms, the digital assets, Facebook, Instagram, all of those things, where those are all assets. You need to write them all down on a list and figure out what you're going to do with them. Identify the goals that are important to you, and be honest with yourself about your goals, who you have, what do you have. Always review your beneficiary designations. And what I feel is most important, you don't know what you don't know, so you need to get trusted advisors. Start with a financial advisor. You can get an accountant, an attorney, someone who knows what they're doing, for God's sakes, to be able to point you in the right direction at a time that you may not be able to know that you need to be pointed. I have had a radio show. If you go on YouTube, you can get some of this information on YouTube, where I say the same thing over and over again. And I'm actually going to start doing some live TV stuff. So follow that page, and you can get more free information, because this is the only way I'm giving it for free. That's my contact information. If you need me, I am going to quickly, because I know we're at the hour, look at some of these questions to see if there's anything that I can answer. How many personal representatives do you suggest to have for a single parent with one child? If you have more than one, great, but whomever you trust. Does the trust have to pay taxes? There are multiple types of taxes. There's capital gains tax, there's income tax, there are a bunch of taxes. Yes, the trust is an entity, and at any time it may have to pay any of those taxes. What is the benefit of registering your will now versus keeping it in a safe place? I don't know that there is. I don't know. It's really a personal decision. My mother prepaying for her funeral was the best thing. Could be good. I think that's all of the questions I can read really quickly, and some of these are already answered. Let's see. Will you need a will if you have a POD? I think I answered that. Will covers everything outside of POD life estate deeds. I think you need, everyone who's breathing with income needs a will, advanced medical directive, and a power of attorney without regard to the beneficiary designations. Just my legal opinion.
Oh my goodness. That was amazing. And I can't believe you came in just about to the hour. Shari, thank you so much. I think you probably couldn't see the chat, but like, questions are popping. I hope everyone that you understand why this is such an important process to do. And please don't let the cost be a barrier. The cost of not putting plans in place is so much greater than what putting plans in place can cost you at this point. And there are lots of options. I would recommend tomorrow's session on getting it right the first time. If you don't have a session, I'm sorry, if you don't have plans in place, come to that session, or we will be sending the recording to all of these at the end of the week. But there is a lot that's encompassed. That's not just who gets the prized skillet from the kitchen. So Shari, I want to thank you so much. I want to thank everyone else. We will be sending recordings at the end of the week, as well as a survey, and I hope that you will come back for more, because this is just the beginning and there's a lot to cover. So thank you all. Hope you have a great day, and we'll see you again soon. Take care.